Good evening, everyone. I'm Marianne Vega Clancy. I'm the president of the League of Women Voters of North County, San Diego, and I welcome you to tonight's seminar, Birthright Citizenship from the 14th Amendment to the Supreme Court. But before we start, I would like to say there's just a few words and remind us that 105 years ago, in 1920, the League of Women Voters was created, and we then, as now, remain committed to our core mission to educate, advocate, and encourage informed and active participation in our government, in our democracy. We do not support or oppose any political party or candidate. And we do strive to ensure that every voice is heard and that every citizen is empowered to engage fully in the democratic process. So education is one of our core missions and one of our values. And in that spirit, I am delighted to welcome tonight's guest speaker, Dr. Abigail Stepnitz, Assistant Professor of Political Science and International Relations at the University of San Diego. Dr. Stepnitz brings a rich blend of academic expertise and real-world insight. She holds a BA in politics from the University of San Francisco, a master's in human rights from the London School of Economics, and a PhD in jurisprudence and social policy from UC Berkeley. At UCSD, she teaches law and society, constitutional law, immigration, climate change, and popular culture, all topics at the heart of many of today's most pressing public conversations. Tonight, Dr. Stepnitz will be addressing a very timely and critical issue currently at the forefront of national discussion: birthright citizenship. With the US Supreme Court now, this very moment, considering a case that could redefine the constitutional right to citizenship by birth as soon as this week, tonight's conversation could not be more urgent or more consequential. So please join me in extending a warm welcome to Dr. Abigail Stepnitz.
Thank you, Marianne. This is great. I'm really excited to be here. I will jump to the punchline, which is to say, I don't think the court is going to do that, but we'll work back from there. I don't see that on the horizon, but it is possible. And if I've learned nothing since 2016, it's that I should stop making guesses about things. So I don't even really need to introduce myself. I had a little agenda here for us tonight. I was going to introduce myself a little bit, but Marianne did a great job of that, so not needed. What's at stake? Well, I'll sort of talk about how we got here. Why is birthright citizenship back on the agenda? And in a way, it never really left the agenda. We'll talk a little bit about that. I have some video clips from the 90s, the early 2000s. Some of these conversations have been around a very, very long time. So we'll talk about that, and we'll talk about why it's perhaps back with a particular vehemence. Now, I'm going to start with quite a bit of legal and constitutional history. I don't want it to be boring, but it's really important that we understand where we came from. So I'm going to go through that. I'm an academic, and so I really like a footnote. A bit of extra reading, if you will. And so all of these slides, which I believe that you have, if you look in the presenter notes section, there are footnotes, there are book suggestions, there are articles that you can read. Not to say that I can't dig in and answer questions. I'd love to do that, but there's plenty of extra stuff in there as well. So you can take a look and follow any of those links if you like. Then I'll talk about the current Supreme Court case, Trump v. Casa Inc., and kind of how we got there, what I think might happen. We just had graduation, and the students give each faculty member an award. And the awards are quite tongue-in-cheek, as you can imagine. But my award was the Oracle Award for predicting the, in parentheses, sometimes awful future. And I've been joking about that because I keep saying to them, I'm not a witch. I can just read, and so let's see how I do with my predicting of the future tonight. And then we'll do some Q&A at the end. So if you have questions in the meantime, though, jump in, ask me. I feel fine about that. So let's get started. So birthright citizenship, right? In the United States, we do not require any child born here to prove anything about their citizenship or their status or their parents' citizenship or their parents' status when they are born, right? If you've had a baby or been in the room with someone who's recently had a baby, they just bring you some paperwork and you fill it out, right? And a few weeks later, you go to the county and you get a birth certificate. Um, is that the way that it should be? Right? We have to ask ourselves some normative questions here. How do we want to organize access to the political community? Right? How do we want to think about who becomes part of what we would call American? You can see I've got some points here on the slide, right? Is it an accident of birth? Perhaps. Um, if people know they can become citizens or their children can become citizens by virtue of presence, does that incentivize migration? Does it incentivize dangerous migration? Right? Should we move away from a purely birth model because so many of what we might think of as our peer countries, Britain, France, Germany, the Nordic countries, should we move to a model like most of them have, which we might call a birth plus? So it's important where you're born, but it's more important the bloodline that you inherit from your parents. You inherit their status in most places. Perhaps, right? But we have a very particular history. We are a little tiny baby country compared to a lot of those places. And we have a very particular history with regard to the way that movement has shaped who we are and how we have used racialized violence to exclude people and to limit access to citizenship. And so I'm not sure our question is the same as Britain's question or Germany's question, right? We have our own questions, right? We have our own context. So I want to talk about that part first, and then we'll get up to our current moment. Okay. So if we go back, we can go back all the way, right? We can go back to the earliest settlers arriving in the US, and there's everything about this country is rooted in movement. Early European arrivals, mostly Northern and Western European migrants, right? We think of these people, these early people, as the pilgrims or the settlers, right? These are folks whose stories are rooted in intentional movement, right? And we can talk about how voluntary it was. There are people who were, of course, excited by the prospect of adventure, right? Sold a bit of a myth about empty land, promises about the possibility of getting rich, and some of them trying to escape a legal or political climate in their country of origin that they found unfair or stifling, right? Trying to try something new. This is the story we tell about those white settlers who first arrived. Obviously, we have several hundred years of the forced movement of enslaved Black Americans, right? People who would become 12% of the population, eventually almost all of whom moved in voluntarily. Genocidal displacement of Native Americans, especially as the country moved west to try and occupy the whole of what we now consider the US continent. And then movement, a mix of voluntary and forced, especially for labor purposes. And this applies to so many folks from around the world, but I will focus in particular today on folks from Mexico and China, because those are sort of flashpoints in the history, right? So this is not a country that can be understood outside of the context of movement. And I think that's one of the things that makes our citizenship conversation different than that of other countries. So it may be a surprise. I mean, I don't. Perhaps you've been checking up on the Constitution lately. It's probably a good idea, but it may come as a surprise to some folks that the Constitution is absolutely silent on the question of immigration. The Constitution, as written, as ratified in 1787, it contains one line Congress shall establish a uniform rule for naturalization. And that applied only to people who sought to become citizens. It had nothing to do with border crossing or admission or how long people could stay or if they could be barred from entry or forced to leave. We didn't do any of that then. And so, based on instructions from the Constitution, Congress establishes a rule in 1790 in which they say free white persons who'd been in the US for 2 years with good moral character, who swore an oath to the Constitution, those people could become citizens. If you ever spent any time on Ancestry.com or any of those genealogy websites or on the National Archives website, you can actually find loads of old citizenship declarations, especially in your larger East Coast cities, places like New York and Philadelphia. And you can see that someone would go before a justice of the peace and they would say, do you have a witness here who says that you're of good moral character? And they would say yes. And they would say, do you promise to uphold the Constitution? And they would say yes, and then they would become a citizen, right? So it was a fairly straightforward process. But free white persons, right? That did, in practice, create some limitations, right? So anyone who was an indentured laborer, anyone who had signed a labor contract in exchange for their passage over the Atlantic, right? Those folks were excluded, as of course were all people of color, including Native Americans, right? So we had far more attention on this question of who could be a citizen than on this question of migration for basically 100 years. We wouldn't get our first immigration law that looks anything like what we would consider to be an immigration law until the 1880s, right? And these are some early cartoons here, right? You can see down here in the bottom, you have Uncle Sam welcoming people under a sign, right? It says, no oppressive taxes, no kings, no compulsory military service, right? Citizenship, right? Lady Liberty up at the top there, she's stirring this kind of melting pot of citizenship with her equal rights spoon. And then you can see the tone changes a bit in some of the others here, right? We see some anti-Semitic depictions in the bottom right corner, the stranger at our gate, right? We see some suspicious, um, some language of suspicion about migrants arriving. These are the kind of earliest depictions here, right? So a little bit of perhaps social unrest, social uncertainty that starts to brew. And that will become more and more true after the end of the Civil War. But for that almost 100-year period between the ratifying of the Constitution and the end of the Civil War, it is a fairly unregulated process. When we did start to bring in restrictions, those early restrictions were almost exclusively race-based. So we had Black Americans were the first to be officially excluded from a pathway to citizenship in 1857, right? That wouldn't change until the passage of the 14th Amendment. Mexican Americans are able to access citizenship owing to the terms of the Treaty of Guadalupe Hidalgo and the end of the Mexican American War. And in some ways, Mexican Americans will be the exception that proves the rule because almost every racialized decision that will come after that will seek to exclude people again, right? Chinese migrants in 1882, pretty much the entirety of Asia, bar the Philippines by 1917, and Native Americans excluded in practice, excluded by the courts in 1884, and not included in birthright citizenship until 1924. Apologies, that is Ollie. That is my dog. She doesn't think we should have neighbors. She thinks we should just be left alone. All right, so again, in terms of these important points in history, right? Dred Scott, a case probably some of you've read before, right? Dred Scott stands out as part of our national story here. So Dred Scott was an enslaved man, and You know, his wife and his family get kind of written out of the historical picture here, but he and his wife actually brought this suit together. He and she had both been enslaved, and they'd been enslaved in both free and slave states throughout the 1840s and the 1850s. One of the people who claimed ownership of them had been in the military, and so when he was moved by the military, there was a point at which um, the Scots lived in a free state, right? They lived in Missouri, and they'd moved around. They'd been in Illinois, and so they came back to Missouri, and they said, if we've been in a free state, perhaps we are now free people, right? Is that something that can kind of attach to us? And the historical record is a little bit incomplete here, but um, the kind of rough understanding is that they had two daughters, Lizzie and Eliza, and their daughters were approaching the age at which they were probably going to be sold to be slaves owned by other people. And so, in part, Dred Scott and his wife Harriet, they brought this suit at the time in an effort to keep their family together. So he files suit in Missouri, and eventually the case is heard. And this guy in the black and white on the left of the screen over here, this is Roger Taney, and he he ends up being probably one of our most famous Supreme Court justices. I'll talk a little bit more about Taney later because it turns out that he is also responsible for telling Lincoln he couldn't suspend habeas in Maryland. So we'll talk about that in a little bit. But Justice Taney, noted segregationist and racist, says no, absolutely not. Um, eh, and what he could have started by saying was, if you're not a citizen, you are not allowed to bring a lawsuit in federal court, right? The technical term is you don't have standing. And he could have stopped there and he could have said, Dred Scott doesn't have standing, he can't sue, this is moot. But instead of saying just that, he said he has no standing, this is moot. And as you can see on the screen here, a Negro whose ancestors were imported and sold as slaves, whether enslaved or free, could never be a citizen, right? So he goes beyond just determining whether or not Dred Scott and his wife and his children, right, if they were citizens, to say there's no possibility here, right? Anyone descended from any slave, no matter how much time had passed, was considered property under the Fifth Amendment, right, rather than a person. And Dred Scott, this case is so important for thinking about why the language of the 14th Amendment is structured the way that it is. Why we couldn't just say, oh, actually, any Black American freed after 1868 and the end of the Civil War. You can imagine how complex that would have been, right? And especially faced with the hostile reality of the post-war South, and the fact that you had several states that would have tried to get around some kind of narrow reading of citizenship. The more expansive language makes sense in this historical context, right? So what does the 14th Amendment say? It has several sections. We are only going to talk about section 1. This is the birthright clause, the citizenship clause of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Right. So much about this language is an attempt to force the South to fall in line after the war, an attempt to say you aren't going to legislate your way out of the extension of full rights to freed Black Americans. We can, of course, debate perhaps maybe on another evening the successes and failures of Reconstruction and why maybe the full vision of the 14th Amendment has never really been realized. But we can see the efforts here, right? This is an amendment written at a very specific point in time in a deeply fractured country with a Supreme Court precedent that was so broad that the remedy had to be equally broad, right? And we can see underneath that the additional clauses, right? the Privileges and Immunities Clause, which basically says the state can't take away your federal rights. Your rights are your rights. You carry them around with you in your pocket. And no matter where you go, Georgia can't say, oh gosh, I'm so sorry. Unfortunately, you don't qualify for First Amendment protections here because of who you are or something about your identity, right? Nevada can't say, oh, well, we don't actually mind who owns or doesn't own guns here. We're going to take your guns away if we feel like it, right? Everybody gets to keep their federal rights. And a reiteration of the Fifth Amendment due process clause. No arbitrary deprivation of life, liberty, or property without due protection of law, and no denial to any person, equal protection of the laws, right? So much of this tells us about the country that we were hopeful to build in this post-war era. And yet, the very seeds of our current debate are contained in here as well, right? This language of being subject to the jurisdiction in particular is what we will be coming back to, because most of the contemporary debates are rooted in that language, right? So at this time, right, post-war, we still don't really have any immigration restrictions. We have citizenship if you are either a free white person, because that was what was contained in the original act. Now we have citizenship if you were born in the United States, right? Birthright citizenship. But public opinion will start to shift. Perhaps unsurprisingly, after the end of the war, there were a lot of people who had relied on slave labor who could no longer do that. And to replace slave labor, a lot of people turned to migrant labor and to Chinese laborers in particular. So as the number of Chinese migrants began to increase, we saw increasing social hostility, and so many of the arguments are very, very familiar. So I can show you some of the cartoons from the time as well. Um, you know, communists, nihilists, socialists, etc. Right? You're welcome, but no, not if you're a Chinese migrant. Right? We're going to build a Chinese wall around the United States. This kind of caricature of Chinese migrants and really virulent anti-Chinese sentiment is also something that's rooted heavily in California, right? This is a particular shame of ours as Californians. Leland Stanford, maybe you've heard of him. Personally, I went to Berkeley. I wouldn't know. But Leland Stanford ran for governor of California in the 1850s on a specifically anti-Chinese platform, anti-Chinese migrant platform. And so it was very, very clear that he was reflecting a general sort of shift, right, in the way that people thought about citizenship and thought about admission to the country. Um, there we go. Sorry. On the back of this, we will get a bunch of legislation starting in 1882 that seeks to exclude people based on race. Um, the Chinese Exclusion Act is probably the most famous, but we have a whole bunch of other pieces of legislation that are passed at this time that are designed to limit who can enter the country. And that will continue right up until the 1920s. I'll talk a little bit more about that in a minute. For those of you keeping track at home, right, we have citizenship if you are a free white person. We have expanded access to citizenship if you are born in the country. But there is a contemporary understanding in that sort of post-war moment that we are talking about freed Black Americans and that it is meant to be tied to that, right? So in 1898, rather, we get the first test at the Supreme Court of the boundaries of birthright citizenship. Wong Kim Ark is born in San Francisco in the 1870s, but his parents are non-citizens. They are from China. They return to China on a trip. And when they come back, the Chinese Exclusion Act has been passed, as well as some other anti-Chinese legislation. And they did not have the correct paperwork to re-enter. They needed certificates of residence, and they couldn't prove. This happened to a lot of Chinese migrants at the time, especially folks who had the misfortune of just being out of the country when the legislation was passed. And then because the journey back to the States was very long, many people who arrived back in the US having no idea that the laws had changed. And so his parents found themselves not able to comply. But the question was, well, he was born in San Francisco. Is he a citizen? Right. And the Supreme Court says, yeah, he is, right? He is a citizen, and we only have a limited number of exceptions to birthright citizenship. The children of diplomats, the children born to invading or occupying armies, and Native Americans, right, who will not be granted birthright citizenship until 1924 through statute, a slightly different path. And this remains true, children of diplomats and children of invading occupying armies, this remains true today. And people will say that, if you are in New York City, for example, you're somewhere near the United Nations, this is why you can't park anywhere, because the children of diplomats never have to pay parking tickets, right? So they park where they want. It is still true, right? That they are set outside of the entire system. They can't be prosecuted. They're not citizens. It's a separate set of rules. And so over the next 120 years or so, the court will actually be asked questions about this several times. They'll be asked, what if you are born here, but your parents entered the country illegally? And they'll say, you're still a citizen. And they'll say, what if you were born here, but only after your parents had actually been intercepted by Customs and Border Patrol, right? Perhaps your mother is even detained in an immigration detention center near the border when you are born. And the court said, yeah, you're still a citizen, right? They'll have another case where they'll say, what if your parents were US citizens, naturalized citizens, but it came to pass that they had acquired that fraudulently? What if they lied in their pursuit to get citizenship? Are you still a citizen? And the courts would say, yeah, right? So interestingly, if you listen to the oral arguments, which I'm a big fan of, I think everyone should be listening to the court like a podcast all the time. I personally find it really interesting. You go do your grocery shopping, whatever you're doing, you just take the court with you. But you'll hear Justice Kagan say, by my count, any attempt to overturn birthright citizenship violates at least 4 Supreme Court precedents, right? They've been asked repeatedly what the boundaries are, and they have had this expansive reading rooted in this 14th Amendment understanding that is really broad. If you're born here, you're a citizen, right? So it seems like we would think this should be pretty established. Between the 14th Amendment and the decision in Wong Kim Ark, we have a legislative position, right? Through Congress's approval of the 14th Amendment, we have the Supreme Court on board in Wong Kim Ark, right? The only officially racialized restriction left applied to Native Americans when it comes to birthright citizenship, right? Um, and most of the attention shifted to the focus on limiting access to the country in the first place. So we will see a much slower path when it comes to naturalization. So people who were born outside the US and moved to the country and then hope to become citizens later. The restrictions on naturalized citizenship, as you can see, you could only be Black or white to seek naturalization. And that was true until 1952, right? The year my mother was born, not that long ago, all things considered, right? Certainly not the 1857 of Dred Scott or the 1790 of the Naturalization Act, not the kind of thing that makes us think about ancient history. At the same time, and I won't spend much time on this, but I just like to flag this. At the same time that we were trying to figure out how we could exclude people from naturalized citizenship on the basis of race, we passed a whole bunch of legislation on what we would call qualitative bases of exclusion. And so you can see this really interesting and emerging picture of who we thought we wanted to keep out, right? Immoral purposes, anyone who had diseases or was a criminal, a lot of focus on prostitution and procurement of sex work, gambling, being an addict, lots of vice, right? The kind of thing that will come to shape some of our global reputation in the early 20th century, right? A real focus on that. So there's a picture that emerges here that is heavily racialized and that is beginning to connect migrants with undesirability, right? And this language, obviously, much of this language is really anachronistic and offensive, right? We don't use the language of insane persons anymore, right? But most of this is deeply tied to suspicion about migrants generally. So you can see this picture taking shape, right? This is 1903. Um, Interestingly, also feels a bit like a cartoon that you might see today, with a slightly more modern drawing, right? But this idea that waves of people are coming in, that you have this high tide. It's a bit hard to see, but if you kind of zoom in and look at the hats that the people in the water are wearing, they say things like mafia, criminal, outlaw, anarchist, illiterate, pauper, right? Things that, again, maybe the vocabulary is a bit more modern, but many of the same critiques that we are looking at in 2025, right? And so this is not a lot of this is not new. Throughout the 1920s, we will continue to make this worse and worse, right? The Supreme Court will spend a lot of time trying to determine, because if naturalized citizens can only be white or black, and perhaps unsurprisingly, there were not many people in the 1920s who sought to be classified as Black in the United States. Most people who tried to make a claim for citizenship would have to make a claim for whiteness, and the court will spend decades. They'll do more than 50 cases trying to draw boundaries around whiteness and not really even being sure what that means. I've got a great book recommendation on that if you're interested. And at the same time, new quota-based immigration systems that sought to restrict immigration and to favor those countries who had what they might call like the original stock, the founding stock. And so if you were British or Danish or Norwegian or something, it would be a bit easier for you to come in. And we start to see restrictions even on Eastern and Southern Europe, discrimination against Irish and Italians, and the anti-Semitism of rejecting Jewish migrants, right? We start to see a lot of that taking shape in the restrictions to access to the country in the first place. So even if, and there were questionable boundaries around whiteness at the time, right? Italians and the Irish weren't considered white for a long time. But even if you were from a country where you were considered to be white, if there were already too many migrants from that country coming into the US, you might be excluded as well. So a system that is perhaps a bit more akin to what we have now, this is taking shape through the 1920s. We get a big landmark piece of legislation in 1924. The cartoon on the page here with the funnel and the little 3%, this is a cartoon about the 1924 immigration law. In 1952, we get the Immigration and Nationality Act. That is what we still use today. It is huge. It has been amended more times than can be counted. It is the second wordiest body of law after the tax code, which is amended perhaps even more frequently. And we have a very complex system now of who can enter and under what circumstances, and some of it's numerical and some of it's tied to categories, right? But we don't have any more racial restrictions that are facially racial, right? Nothing in the law anymore says anything about limits on access to citizenship because you are Chinese or Japanese or Russian or Jewish or Black. There's nothing left like that, right? Again, on another day, we could talk about what the system does in practice, but it is a formally equal instrument that is supposed to distribute access to immigration in a way that is, I suppose, at least race neutral. So if anyone born in the US is a citizen by birth, and by 1952, anyone who would otherwise be eligible, right, could naturalize, are we not pretty settled? Well, not really, right? Because we are back to debating this clause here, right? This is again from the language of the 14th. Persons born or naturalized and subject to the jurisdiction of the laws, right? And so people begin to ask questions about what that means. If diplomats aren't subject to our jurisdiction, if they can't be prosecuted for their unpaid parking tickets, then how is the child of a diplomat any different from the child of a tourist, right? How is someone who is here on a student visa for 4 years and perhaps has no intention of making a long-term life in the country? Why would that person, should they happen to give birth while they're here, give birth to an American citizen? And to answer that question, or to answer those questions, to think about them meaningfully, I think we have to ask ourselves where we think membership in our community comes from. Right. And so one way to think about that is to think about ascriptive membership, right? So you didn't do anything to get the status that you have. You didn't have to prove anything. You didn't have to pass any kind of a test or attest to anything or swear an oath of allegiance of any kind, right? You were just born where you were born to the parents that you were born to, and whatever status you have that flows from that, right? That's your status, right? Most countries in the world have some combination of what we would either call jus soli, right, of the law of the soil, where you are born physically, geographically, determines some part of your status, or jus sanguinis, right, which is the law of blood. So the status of your parents, the status of the people whose blood you share, right, that is an inherited status when you are born. And so do we want to limit this based on those types of memberships, right? Or do we want to think about a consensual approach where people need to be able to uh, freely choose, right? But also those who are near them need to be able to have a say, right? Should people who are part of a political community have a say in who else gets to join them? There are countries in the world who take this very, very, very seriously. Places like Switzerland, where it takes a very long time to become a citizen, and you are subjected to the views heavily to the views of the people who live near to you, right? And on the other end, there's the US, right, where there is no consultation, there is no process, right? And so these give us a helpful jumping off point. They're not the only two frames, but I think they're quite useful. So what kind of system do we have, right? We have a system where you are just born here, and the people who we tend to talk about when people are critical of this system are always the same group. It is the children of undocumented migrants. I have yet to see anyone say something like, well, everyone's citizenship should be provisional until you turn 18, and then you pass a citizenship test or you pass some kind of civics test, and you show that you know, are a person of good moral character who wishes to uphold the values of the Constitution. I don't see any suggestions that those children be subject to any kind of test or vetting in order to become citizens. It's just the citizens of undocumented migrants, right? And again, the concern here is usually if your parents were not subject to the jurisdiction of the 14th Amendment, then did the people who authored the 14th Amendment intend for you to be a citizen, right? Is that what they were thinking about? Or do the children of unauthorized immigrants or undocumented immigrants, do they belong in the bucket with the children of diplomats, right? Does that make more sense? So I'm hoping these are going to work through the screen sharing. It's just occurred to me that these are little videos here. So let's see if we can listen to Bill Clinton for a minute here. Mm, Doesn't seem doesn't seem to want to work that way. Let me see if I can do it in a small in the small screen here. Oh, it's such a shame because he works so brilliantly when the screen is not being shared. but that's okay. I think what I will do is share it, or I'll open it in, I'll open it here, and then I'll share my screen with you. Oh, there we go. Let's see. So this is from Bill Clinton's State of the Union address in 1995. And he goes on to be pretty famous for this phrase, right? We are a nation of immigrants, but we're also a nation of laws. So let's see what he has to say.
Abigail, we're not hearing the sound.
Oh, well, that's not great, is it? Let me just see if share sound. Let's try it again.
All Americans, not only in the states most heavily affected, but in every place in this country, are rightly disturbed by the large numbers of illegal aliens entering our country. The jobs they hold might otherwise be held by citizens or legal immigrants. The public service they use impose burdens on our taxpayers. That's why our administration has moved aggressively to secure our borders more, by hiring a record number of new border guards, by deporting twice as many criminal aliens as ever before, by cracking down on illegal hiring, by barring welfare benefits to illegal aliens. In the budget I will present to you, we will try to do more to speed the deportation of illegal aliens who are arrested for crimes, to better identify illegal aliens in the workplace as recommended by the commission headed by former Congresswoman Barbara Jordan. We are a nation of immigrants, but we are also a nation of laws. It is wrong and ultimately self-defeating for a nation of immigrants to permit the kind of abuse of our immigration laws we have seen in recent years, and we must do more to stop it.
Right. So this is perhaps familiar, right? You've maybe heard this before. This idea that, oh, there we go. Right. This idea that we can only have one or the other, right? We can either let people migrate, right, and which means some kind of abdication of legal responsibility, right? Or we can have full enforcement of the laws. Um, Right. So then I think given the slight complexity here, I'm not going to play these two for you. I will suggest that you check them later. This is the 2011 O'Reilly factor. Chris Kobach here, he is a bit of an architect of the anti-birthright citizenship movement, the contemporary one. He's been Secretary of State of everywhere. He moves around a lot. He was in Kansas for a while. Then he was in Arizona, and he has a bit of a bee in his bonnet about birthright citizenship, and he kind of launches this debate back into our kind of contemporary dialogue in about 2011. Right. And then, of course, perhaps unsurprisingly, we get this back with the Trump campaign. There was a little bit of discussion about it in the first Trump administration, but it did not get anywhere near the kind of focus that it has had in the second Trump administration. So, I think it's important. We could go back farther. Let me just say, right? We could go back. We could look at Reagan. We could keep going all the way back in a very bipartisan way. We could go back and forth between all different types of candidates who have made various promises about what to do about undocumented migration, right? And we could have a whole separate conversation about the causes of undocumented migration. And in fact, how Bill Clinton's own largest piece of immigration law in 1996 would do perhaps the most damage to any type of effort to provide a pathway for citizenship, or even for perhaps a more sensible and humane conversation about undocumented migration. And that conversation has seemed out of our grasp. right? We've had no success at comprehensive immigration reform. So, right, that is to say, this conversation about birthright citizenship, while in some ways it feels like it's just been thrust right back in front of us, has actually been bubbling away for a really long time, and it comes to the front sometimes and recedes others, right? But so what does it mean, this question of being subject to the jurisdiction of the laws of the US, right? If you can be arrested, if you can be prosecuted or convicted of a crime, if you can go to jail, are you not subject to the jurisdiction of the US? If your earnings are taxed, is that not a way that you are being subject to our laws? If you would have to pay civil penalties, those feel like ways that folks are being subject to our laws, right? And even if you aren't, is that a burden that should be inherited by your children, right? We have basically no other areas of the law where your child can inherit your legal obligation, right? We don't have inherited, mostly, we don't have inherited debts, right? We certainly don't have inherited criminal records. To inherit your parents' unlawful status, if you yourself were born in the US, would set birthright citizenship quite apart from other ways that we manage heritability and questions of violations of the law. Right? And it must be said, right, that immigration law is civil law, it is not criminal law. And even though there are criminal penalties that can be attached to entering without inspection, illegal status, right, or undocumented status is not a criminal status, it is a civil status. And so, do we want that to be something that passes from parent to child? Is that how we want to run our country? So, does our specific history matter here, right? I said this in the beginning. I think in a lot of ways that it does, right? It would be very hard, I think, for us to decide when and where to draw lines around who would be included and excluded. Um, until it was gutted in 2013, the Voting Rights Act and several other pieces of legislation that we still have, this Civil Rights Act, right? Most of the legislation that came out of the civil rights movement in the 60s, protections around employment, protections around housing, right? Those are there because we spent hundreds of years using the law against people. And not to be too pessimistic, but I worry that if we took the guardrails off, we might see some of that come back. So I doubt very much that an open conversation about what if we limited access to citizenship would produce a thoughtful, humane, racially neutral arrangement that everyone could be proud of, right? That isn't the history that we are looking at. And we have improved and we have changed in some ways, but our specific history, I think, really does matter here, right? And in some ways, I think we have to ask ourselves how much your place of birth is morally relevant. I'm going to suggest another book to you at the end about the fact that the place you're born is a bit of a lottery. And so if you inherit citizenship in a wealthy Western democracy, is that not the modern equivalent of feudal privilege? Are you someone who got lucky? I certainly didn't earn where I was born any more than anyone else did. And so how we think about this as a kind of moral question, right? That's relevant for our conversation too. What are these critiques, though, of our present, right? Our past matters, perhaps our present matters as well, right? Questions of birth tourism, this idea that people are intentionally arriving heavily pregnant, seeking to give birth just to secure birthright citizenship for a child. This notion of anchor babies, right? That if you have a baby here, that child will become a sort of foothold in the country and create a pathway, certainly for the immediate family, or perhaps even, right, the language of chain migration for these long chains of migrants to follow, long chains that almost all of us find ourselves at the end of. I say this to my students all the time. It is wild to me to be in a country where we aren't sure if we want to let newly arrived people be part of America, and where ancestry DNA kits to find out where you're really from top the Christmas list every year, right? And so we have this kind of fascination with being from other places, and this quite virulent opposition to being a place where people came from somewhere else. But anyway, right. So let's take the critique seriously, though, right? These are the critiques, and they've been levied many times. So let's confront them with some seriousness. Okay, so oh, can't see my own question because of my header. That's okay. All right. So what kinds of benefits can flow to the undocumented parents or family members of a US born child? Let's say that you are not a citizen, you arrive in the country, you enter without inspection, right? And while you are here in an undocumented status, you have a child. What can that child do for you, right? Children cannot prevent the deportation of their parents. That is not how the law works, right? Citizen children are removed with non-citizen parents with some regularity. This was in the news a couple of weeks ago. 3 children who were removed to Honduras, with a citizen parent. Those are not necessarily always bad choices. They are consequential choices made in a sea of very difficult facts. Would it be better for the state to maintain custody of children and send their parents away from them? I don't think we would prefer that either. But it is important to note that many parents, if they face removal, will say, well, my children will be coming with me, right? So if we're talking about whose status has a greater likelihood of affecting whose life, it is certainly the parent's status affecting the lives of a child while that child is under 18. Now, if you have a US citizen child and you are supposed to be removed, there are some waivers, some basically applications for mercy that you can make to the state to ask to stay. It's very, very hard. You have to meet a threshold called extreme hardship. It's not granted that frequently, and absolutely no publicly available data are kept on how often it is successful. So anecdotally, it's not that common, right? And this is especially true if you have one citizen parent and one non-citizen parent. The courts have tended to be fairly comfortable with the idea that one parent is enough, and the other parent, if removed, can see the child on holiday or something, and that would be sufficient. Even if your child, if you stay in the country long enough for your child to be able to sponsor you, they cannot do that until they're 21. So if you are undocumented and you have a child, and for somehow you manage to evade any trouble for 21 years, and your child wants to then sponsor you to enter the country legally as someone who would be a green card holder and then eventually able to claim citizenship, they could do that, right? Only applies readily, easily to immediate relatives. So that's your parents, your spouse, and your children. If you're 21, it's less likely that you have non-citizen children or a non-citizen spouse, right? It's most likely that we're talking about your parents here. But if you have been unlawfully present in the country for a very long time, by the math of this exact example, at least 21 years, you could face a very difficult set of choices when it comes to re-enter. Because if you go to what we call adjust your status from inside the country, you put your hand up to the federal government and you say, I've been here illegally for 21 years, but my child is a citizen and they want to sponsor me, there are going to be some consequences to that choice. And the fact that you were here illegally can make you subject to removal. And if you are removed, you can have a reentry bar. You can be someone who is not allowed to come back into the country, right? Your other option would be to leave the country and to apply from outside, right? This is the so-called right way. We hear about this, right? You could leave the country. Obviously, you have to not be intercepted before you leave the country. But let's presume that somehow you manage to leave the country and you aren't detected at the border. It's going to be pretty hard for you to show what you've been doing for the last 20 years. You don't have an address, you haven't been paying taxes, right? Probably in your country of origin. You certainly be difficult perhaps to marshal those documents in support of what you've been doing. And so the path from I had this baby 21 years ago, and now this baby is going to turn me into a citizen, is very fraught with landmines. It is not an easy path, and it is certainly not a guaranteed one. Um, if you are talking about anyone past that, or anyone in that first group, parents, spouses, and children, you're looking at something like an 18-month wait time, right? So perhaps if you, again, you manage to leave the country and you're outside and you apply from outside and all the paperwork seems to be working, you could be looking at as little of an interruption to your life as 18 months. Obviously, many things have had to go right for you at this point. But what if you weren't a parent, right? What if you were a sibling? What if when your parents entered without inspection, they entered with your older brother who was born in Mexico and you were born here, and now you would like to sponsor your brother? Well, it's going to be a 24-year wait under the current wait times. This is called the Visa Bulletin, this little chart that I have down here. The State Department issues a new one every month with updated wait times for these different categories. China, India, Mexico, and the Philippines are the most impacted in terms of waits. That's why they get their own categories here. And the other countries you can see are under the chargeability areas. That would be everywhere else in the world. And these categories, F1, F2, et cetera, I'll give you a little description of them in the presenter notes so you can read all about them if you like. But in short, they are a descending preference category for relationships that are considered to matter the most. Siblings are down here in the F4. They are the farthest away relationship that is on the chart. And so you can see that even those siblings who are closest to being considered, these would be folks who applied in 2008. Their applications are being considered now. So any of this conversation about how it becomes a kind of quick ticket for your parents, or this idea that you can establish long-term migration chains, it's not that they're objectively false. It's just that the reality is much more complicated, much more complicated than that. Right. I'm nearly done here. Just a few more things. Right. How many people are we talking about? The estimate of the undocumented population is about 11 million. Very, very hard to count people who don't want to be counted. But that is roughly what we think here. This is from Pew Research, the very reputable research. So if we take that population of 11 million people, and we say, okay, well, what would happen if the people in their families who were born here were also not citizens, right? If those folks and the families that they'd made were full of non-citizen children? Well, you would be adding at least another 1.3 million US born adults, so people who were born here to undocumented parents and who are now adults. And that's very incomplete. The number is probably much higher because the data collection only reflects people who still live with a parent. So we're probably talking mostly about young adults there, right? People kind of under 26. After that, the numbers may be even higher, but we don't have a good way to count those folks. And another 4.5 million US born children under the age of 18 who have, right, an unauthorized immigrant parent. At least one, right? So in theory, you could add at least 50%. You could add another 5 million people to that 11 million. And again, I'm not sure what the value add is to making that population larger, right? So how do we think about this in terms of the current executive order? The order is called Protecting the Meaning and Value of American Citizenship. I've given you a link to it in the notes there. You can have a look if you like. So the argument here again comes back to this language. The 14th Amendment never meant for these folks to be included because they're not subject to the jurisdiction of the law of the United States. They're not subject to our laws. And there's a kind of a set of people who they seek to exclude. And I'm just going to skip over this paragraph because I find it very sloppily constructed. And I have a little chart that I think makes it a lot easier to understand, right? So these would be the two buckets, if you will, of people who would no longer be eligible for citizenship. Why they chose something that is so specific about the different categories of mothers and fathers. Um, we do have some old law about legitimacy and notions of legitimacy that we really haven't talked about in a very long time. Perhaps this is some attempt to resurrect that. But anyway, right? If your father was a non-citizen, right, or not an LPR, right, a lawful permanent resident, or a green card holder. So let's say your father was on a student visa. Your father was a grad student, right? And your mother was undocumented. At the time you were born, you would not be a citizen. Or let's say that your father, again, let's leave him on the student visa, right? And your mother was, actually also a student. You wouldn't be a citizen. I've got a couple of examples for us here, right? Yeah. So what if you have two parents, right, who are on H-1B, specialty occupation, short-term employment visas, right, or student visas, F-1s? If neither parent is either a citizen or a green card holder, right, then you are not going to be, your child would not be a citizen, right? Or if your mother is undocumented, right, and you give birth in the U.S., and she gives birth in the U.S., and the father is on some kind of temporary visa, right, you wouldn't be a citizen. Obviously, this creates the possibility that if your mother did have status, right, and your father was undocumented, as far as I understand it, you would be able to claim citizenship. And it does kind of harken back to really antiquated ideas about legitimacy and parenting. But as I understand it, I will show you the chart again, right? This is the language of the order. So it isn't even so clear as to say, no children of undocumented migrants, right? It is a little bit more complicated than that. It isn't only trying to capture the children of folks who are undocumented, it's also trying to capture the children of folks who have some kind of temporary status. And there's an irony here because some of these categories, whilst they may not immediately lead to citizenship, absolutely have potential for that. Specialty short-term employment visas, we might think stereotypically about folks doing things like agricultural work, but they could just as easily be computer programmers working at Google, right? They could just as easily be nurses or doctors, right? They could just as easily be language teachers or sports people playing sports, right? And those categories might really legitimately lead on to green card and then citizenship status, at which point you could have two parents eligible for citizenship with a non-citizen child, right? Not that something bad would necessarily happen to that child. They would probably be naturalized on their parents' application, but it does seem to create confusion and complication in a lot of ways. So the order was immediately challenged. Within just a few days, you had 22 states challenging it. You had 3 different federal courts weighing in very, very quickly. Up in Washington, in the Ninth Circuit, it was referred to as blatantly unconstitutional and obvious violation, not only of the Wong Kim Ark standard, but those subsequent Supreme Court precedents that I talked about at the beginning. And so this is how we end up on the path to the Supreme Court. Courts, quick overview, right? We have 94 district courts across the country. If you go before a district court judge, you get 1 judge. Above that, you have the circuit courts. We have 12 circuit courts. You get 3. So California's in the Ninth Circuit. You get 3 justices on the circuit court. And then above that, you head off to the Supreme Court. And so right now, if the federal government is breaking the law, one of those other federal courts, lower than the Supreme Court, might issue an injunction, right, or an order for the government to stop behaving the way they're behaving that applies to the entire country, right? The nationwide injunction, right? And they apply to the government, right? If the government is breaking the law, if they are being racist or discriminatory, if they are violating some of their own standards, right, and they are doing it in the Northern District of Texas, we are not inclined to allow them to continue to do that in Wisconsin or Vermont or Hawaii until somebody there makes an independent challenge, right? We say, well, if the government is hurting people, they shouldn't be able to hurt anybody anywhere until we figure it out, right? The administration has said that this is not fair because that means that one district, right? And, we can make some assumptions about how the geography probably plays out here. The Ninth Circuit, the West Coast, perhaps you have the Fourth Circuit on the East Coast, the places that are considered less, perhaps more likely to be antagonistic to the current administration, right? Those judges are going to not let the administration implement their policy agenda, right? And so this is a direct assault on the presidency, right? And becomes a separation of powers issue, right? But if they were to go away, if every nationwide injunction were to go away, you would have a situation where the burden on the people being harmed would be significantly larger. Why should I have to go to court in California if the government is emitting toxic fumes into the air when someone in Vermont already went to court and it was clear that that was an illegal act, right? So you'd have to have a class action for almost everything. And then the question is whether or not the judge you see wants to certify the people being harmed as a class, because maybe they do and maybe they don't. Right? So the arguments on the day, the understanding was that the people who brought the case, they didn't want to talk about the merits, the actual meat, the birthright citizenship question. They only wanted to talk about nationwide injunctions. And so that is what the court did. And I've given you a link in the notes here to the oral arguments and to the transcript if you want to take a look at it or listen to it. It was really long. I think it was 2.5 hours of arguments. So you'll need snacks. But it's very interesting. It's interesting to hear them make their arguments to the justices. And you do hear some of the justices say, I think at one point, I can't remember if it was Kagan or Sotomayor, one of them says, let's presume that you're wrong about this, about the citizenship question. Like, let's just presume that, and uses that as a basis to set up a hypothetical about the nationwide injunctions. So there are moments when you do see the justices reflecting on it. Justice Kavanaugh at one point says, I need you to walk me through how this would work in a hospital room. Like, a baby has just been born. What do we do next? So the justices had the citizenship questions on their mind, even though the organization of the arguments was really heavily focused on the question of nationwide injunctions. So what might come next? What might they do? We could get a very narrow procedural ruling, right? Where they are only going to talk about injunctions and who is allowed to issue nationwide injunctions. And maybe they'll narrow it. Maybe they'll say circuit courts, yes, district courts, no. Maybe they'll say, once you have more than one circuit agreeing with it, who knows? They could come up with any kind of test here, right? But it would be narrow and it would be tied to the procedures. At that point, the substantive question of the constitutional matter, the birthright citizenship, would go back to the lower courts. And they would continue to deal with that based on whatever new guidance came from the court around injunctions. In theory, the court is actually free to rule on the merits, even though that is not what they did during oral arguments. They can make decisions if they think something is sufficiently important, right? They have, it's called the major questions doctrine. And if they want to weigh in on that, they can. I don't think they will, because especially in matters of immigration, the court is very, very deferential to Congress and the executive. It's always been that way. And so I don't know. I think it's unlikely. This path, I think, is unlikely that they decide to weigh in on it anyway. But whatever happens, the actual substance will be back. It'll be back to the court, and I would guess sooner rather than later. So I'm not expecting something in the next month. They've got a lot of big cases to clear. Last year, they had to work into July. Can you imagine? Usually they have all of July off and they don't even come back until October. So they like their holidays. But last year they had to work into July. I don't know if they want to do that again. So we'll see, but I'm not expecting something. I'm expecting a narrow procedural ruling about injunctions, which will be interesting. As a final note, these are some of the books that I suggested. In the notes under this, I've given you links. I've tried where possible to give you links to the San Diego Public Library. The library didn't have all of these, and so where the library didn't have them, I've just given you a link to the publisher. Personally, I'm trying to buy less from Amazon, and so I just thought this way people can make their choices. You can check it out. And I think these are all great. They're all books that I teach from. And so if you want to learn more, this is my set of suggestions, and that's it from me. So thank you for having me, and I'm super happy to do some Q&A now if folks like. And I will stop unless anybody has a question that requires going back on a slide, I can stop my share. What do you think?
It looks like you could stop your share. I haven't heard anybody. I didn't see any
Great.
hands raised or
Okay.
chats go in.
Okay, perfect.
I would just say perhaps, okay, the notes, when I clicked on notes on the bottom, it said I have to sign in.
Oh.
So,
well, I wonder if, because, Marianne, I think you put the presentation in the league's own Google folder. Is that right?
Yes.
So I'm hopeful
I can
that
share it with
then,
everyone afterwards.
perfect, exactly. That then I can see them down there. Yeah, you would be able to get all the links in there.
Yeah. Can everyone see the slide on, for example, the books that Abigail is recommending? I want to read all of these.
Yeah.
But yeah, I can send it out to everyone afterwards. Or,
Perfect.
yeah. Does anyone have any questions? Because I do have some,
okay. One person did send in during the chat, so can we go to that first?
Okay.
I'm not sure. Yeah. Stephen actually put in the fact that he was born outside of the United States, although both his present parents are citizens. So
yeah,
it seems like he's immune from this decision, but perhaps you could comment for him.
Yeah, no, for sure. So there are birthright citizenship is only one of the pathways to citizenship in the US. The others are through inheritance and through naturalization. So if you are born to US citizen parents outside the US, then you are a citizen. And we did have a brief period of time following the Second World War where there was a bit of litigation about about legitimacy. And whether your parents were married, and there was a bit of a gender discrepancy between inheriting citizenship from your mother or your father if your parents weren't married. But that's all done now. And so so now if you were born to citizen parents, then yes, you are a citizen. What about someone who overstayed a student visa and started without the proper visa status, who's had multiple children here? So right now, also let me say, not legal advice, information, not legal advice. Right now, this order was only ever designed to be forward looking. So I believe it's February 19th. I put it in, I checked the date earlier. I'm pretty sure the slide says it's February 19th, 2025. It was only going to apply to people born in the US after that date. Because it is on hold because of the litigation, it's not in force at all, right? It was never designed to be retroactive. It was not supposed to take away the citizenship of people who had already secured it. So any person already born here, up to and including 1 minute ago is a citizen. And that would continue to be true unless or until the Supreme Court were to say that there is some change to the meaning of the 14th Amendment, or something even more drastic were to happen. Crazy hypotheticals about amending the Constitution to change the language of the 14th or something, but something really big would have to happen, and no one's status will change in the meantime. And as of now, there's no proposal to change the status of people who already have it. This would only be about people going forward.
Chris has a question.
Let's see if I'm muted or not.
Okay. No, you're good.
Yeah, I'm good.
Yeah.
In your answer to Stephen, you talked
Mhm.
about if your parents were citizens, what if the
Mhm.
parents are green card holders?
So if your parents are green card holders and you are born in the US, you are a citizen. If your parents are green card holders and you are born outside of the US, you are not a citizen. You don't have any citizenship claim to the US because then you aren't getting it through blood, right? Because your parents aren't citizens,
Right.
and you're not getting it through soil because you're not in the US.
Thank you.
Mhm.
Can I also say this was an incredible amount of information? And
Sorry.
and no, it's okay, but that might be why people aren't asking questions. It's going to take a little while to
You got to percolate.
absorb and understand.
Yes. Um, yes. Terry's question about the change. So I will say a couple of things about the language here. I think the language of illegal. So firstly, let me start with the word alien. Alien is the legal term of art to describe any non-citizen. If you open the Immigration and Nationality Act, which is available fully online, the website looks like it was made in 1995, but it is current and it does work. You will find that like alien is the term that runs all the way through the law. Um, but alien is also a term that has social and cultural connotations that are really negative, right? And there's an assumption that if you are an alien, that you, not even an outer space connotation, but that there's something about you that is uh, undesirable in a foreign way, right? And so moving away from the language of alien and kind of and the language of illegal alien in particular, I think is about centering people. It's also, I think, about reflecting. Remember, I said to you that immigration status is a civil status; it's not a criminal status, and we don't really use the language about illegal person in any other, right? We don't refer to people who are in prison as illegal people. We don't even refer to people who were previously convicted, right, as maintaining some illegality that's attached to them going forward. And so undocumented describes the person, right? Perhaps that person did commit a crime. Maybe they entered the country illegally. Right? Maybe they were prosecuted for something related to illegal entry. And there can be crimes associated with entry and with presence, but those people don't become illegal. And so, if you look up places like the Associated Press have actually stopped using the language of illegal aliens as well. It's just a bit of a linguistic shift that's meant to center the humans as opposed to the actions. Uh, and then military personnel. So military personnel serving in the US military who are not citizens. So if those people have children who are born in the US, if you are stationed here in San Diego, for example, and your children are born here, then you would be those children would be citizens. If you had a non-citizen parent who was serving the US military and was stationed abroad, and you had an additional parent who was also a non-citizen, there's a tiny chance your child could be born on land that is, if your child is born in the embassy or something. It would get kind of sticky. Generally speaking, your child would probably not be a citizen, right? If you were just born in a hospital in Manila, for example, say, because you had a non-citizen parent who was working for the military. Um, But if you had citizen parents, right, because a lot of children are born on military bases around the world to citizen parents, and those children are all citizens, right? We even had this question. I think it's John McCain, I believe, right? He was born abroad because his parents were in the military and they were stationed abroad. And this question of whether he fulfilled the higher threshold of natural born citizen, which is the language requirement to become president, and the answer, to the extent that we have kind of that whole conversation, is yes, right? That he qualified for that as well. Okay. At any time, have children born here been able to keep their parents from being deported? No, and you're exactly right. This is why that language that language of anchor baby is both, offensive, dehumanizing, and pretty legally inaccurate. It is technically possible to say that if you have a US citizen child or US citizen spouse who is dependent on you and your departure from the country would expose them to extreme hardship, you can ask for a waiver for relief from being removed from the country. The threshold for proving extreme hardship is very, very, very high. It won't be something as simple as like, well, I make half of the money every month, and without me, my partner will struggle to pay the rent, and my kids, will grow up with only one parent. That's not going to meet the threshold. It's going to need to be much, much more extreme than that. So the idea that these children are creating pathways, durable, safe, instant, legal pathways for their parents or for anyone beyond that, in practical terms, it's just not real. While it is a technical legal possibility, this is not a big, robust pathway that people are exploiting to migrate. What is the end game for the whole challenge? What is the reason for it? Is it a solution to an actual problem? Uh, the end game, I think, is an interesting question. The court, as I said before, right, they have ruled 4 additional times on the plain meaning of the Birthright Citizenship Clause in the 14th Amendment. I don't think anyone who wants to see a change to who is eligible is going to be satisfied with another reiteration from the court that says the 14th Amendment is clear, and if you're born here, you're a citizen, and that's the end of it, because it isn't really about that, right? I believe on a more fundamental level, it's about um, bigger questions around Americanness and who people think their neighbors should be and what they think their neighbors should look like and what language they think they should speak and what they think their cities and towns should look like. People have very, very strong views, right, about things like that. And one of the proposed solutions from especially from the current administration, but right, as you saw going all the way back to the Clinton clip, right, is that what if we got rid of everybody you didn't like and that solved all of your problems, right? What if the job you can't get is a job you can't get because it's been filled by somebody who doesn't have status? What if your taxes could be lower if someone who's undocumented wasn't on food stamps, right? And like none of those things are real because undocumented people can't access things like food stamps. And most of the jobs filled by folks without status are not jobs that American citizens are clamoring after. I don't see anyone, you've ever driven the 5 North. I don't see anyone clamoring for jobs picking strawberries or almonds or, rearing livestock on the big farms in the Central Valley, in 120-degree heat, stoop labor, 20 hours a day. I don't, for me, that's a non-starter. So I think that's what it's all about, right? Who people want here and who they think deserves to be here and how they think it will change their lives. And so until we deal with those questions as a country, right, as a political community, as a political, social, and cultural community, right, as a multiracial democracy facing the 21st century together, or whatever it is that we're trying to do out here, right, that's the problem. It's not what will these 9 people in robes tell us about, one sentence written in 1868. I don't think that's the end game. Children born as non-citizens and not included in their non-citizens' parents' naturalization at a certain age at what age can be deported? So a child who ages out, who turns 18 and is not naturalized on their parents' application would then be subject to the same restrictions of whatever status they had before that. I'll give you an example here that is pretty common. So if you enter as a refugee, not as an asylum seeker, although I could give a separate example there, but if you enter as a refugee, so for example, in the 70s and 80s, the US received a lot of refugees from South Asia, right, on the back of the Vietnam War. And so if you entered then as a refugee, you're a green card holder. And after 5 years of being a green card holder, you are eligible to apply for citizenship. Now, I don't know off the top of my head how much the citizenship application was in 1980, but I can tell you now it's about $600. So if you have a family of 5 or something like that, you could be looking at a significant outgoing. Not to mention that you would have to be familiar enough with the rules to know that you'd reached eligibility. And you'd have to be able to go and pass the citizenship test and speak sufficient English to do that. And those things aren't insurmountable, but they are barriers, right? So if you didn't do that, and your child turned 18, your child would continue to be a green card holder. Green card holders are held to higher standards in a lot of ways than citizens. So if your child were to commit a crime that as a citizen wouldn't be that big of a deal, shoplifting, trying to think of something else, low level credit card fraud, right? Stole somebody's credit card and used it to buy something online. I'm not saying these crimes don't matter, but these are not crimes that would be life ending to a citizen child, right? And they might take someone who, say, had entered the country in 1980 as a 5-year-old, right, and have them return to a country that they don't remember, right? And so you absolutely could have removal consequences for someone who did not naturalize, right? And unfortunately, a lot of folks, especially who enter as children, sometimes they're just not that familiar. A lot of refugee children in particular grow up thinking that they're already citizens, and are deeply shocked when they learn that they're not. And so it applies to more kids than you might think.
Wow. Thank you, Dr. Stepnitz.
For sure.
This has been fascinating and educational. And I feel like we could
Great.
keep talking about this for another hour and a half.
For sure.
So anyway, thank you. This is I really appreciate it. If you'd like to stick around and listen, I do have some announcements, and some of them might interest you.
Great. Sure.
We do have several upcoming events. Actually, let me share my screen because one of them features Dr. Stepnitz. Okay, here is, can everyone see that? Okay. All right. So our annual meeting is coming up June 14th in just a couple weeks on Saturday at 11 a.m. And Dr. Stepnitz is our featured speaker again. So I hope you enjoyed her presentation. I certainly did. And I'm really looking forward to hearing that. If you would please register. I even learned how to make a code here so that you can scan it and register so that we order enough food. And Mona, if you would please put a registration link in the chat to make it easy. You can also just go to our website and go to events and you can register there. After the meeting, we will have a March for Democracy. Since our meeting takes place during the No Kings marches, and we will miss that opportunity. And the League is not participating specifically in that march. We would like to have our own March for Democracy as a league, and we invite family and friends to attend and march with us. You can bring your own Defending Democracy sign. And we will have a sign making party the week before the annual meeting. I've come up with a bunch of designs and you can make your own as well. So you can pick up a sign at the meeting or you can bring your own. Please bring your sign to the meeting because we all love to see the signs that we make. Just make sure that your sign is about defending democracy and not about any particular party or politician. Otherwise, the message can be very broad. We will walk back out of the building onto Monroe Street, where we will have parked. We will march down Monroe to Carlsbad Village Drive and to the Carlsbad Civic Center, which is about 0.8 miles. We'll take a moment there to reflect, and then we'll march back. People who want a van ride back to their car can catch a van ride. Jen's husband and my husband will be shuttling people back. Then I have a surprise announcement. Tuesday, July 15th, the 2 San Diego County leagues are hosting the League of Women Voters CEO, Selena Stewart. We are having an informal reception at the house of a San Diego League member. So attendance is limited. And if you're interested in attending, it's limited to members only. Just let me know. And I'll register you for that. Email me at president@lwvncsd.org. And then last August 16th at 10 a.m., we will have a live panel discussion on San Diego, money and politics at the Carmel Valley Library. This is also a joint event with the San Diego League. So that's a ways away now in August, but check our calendar to stay up to date. And please do come to the annual meeting and please register. That will really help me a lot. And that's all I have. Thank you, everyone. I really